So we're about to now start the first session, which discusses decolonization of the law in modern Pakistan. If we think about what post-colonial countries have ended up with, certainly in terms of the law, we have a number of laws on our books in different countries that are, in a sense, the residues of the past. And the questions then that might be asked is, are those residues of the past still serving a purpose in Pakistan? So in important issues to address, one might suggest, for instance, that the law is not necessarily bad even if it's aged. On the other hand, it may perhaps prevent the globalization of post-colonial countries. These are important issues to ponder. We might even ask, why is it that in Britain we have laws that are changing and that are being dismantled, but that still exist in post-colonial countries? And those are important issues to debate. We might also ask whether decolonization itself is not taking place in Britain, because it is in a big way, and those debates are ongoing in the colonizer's country, as it were. A further question to ponder is whether indeed colonization means the same thing to everyone. And in fact, there are different definitions of decolonizing. So we have a panel of very distinguished speakers. We have our discussant, Sheikh Raza Rahman. He is an LSE graduate, as many good people are. And he's also a major leading force in the LSE Alumni Association, and he's gathered a number of very distinguished speakers today. He does operate here in Lahore as a lawyer, and his specialty is finance and banking. But I think today he's going to focus on issues of developmental relevance to Pakistan. So, Raza, welcome, and the stage is yours. Thank you.
Okay. Bismillah ar-Rahman ar-Rahim. Ladies and gentlemen, a very warm welcome to you today on this session on decolonizing law for modern Pakistan. Just to correct, I'm the moderator, not the discussant, but I will introduce the discussant. I'm also one of the speakers. As Al-Noor has very rightly, set out very clearly set out the whole theme of the topic, I'll just proceed with introducing our speakers today and including the discussant. I'll start with Dame Maura McGowan. A very warm welcome to you to Pakistan. And the Honorable Justice Maura McGowan is a judge of the High Court of England and Wales. She has a long-standing interest in Pakistan. She's an alumnus of the University of Manchester. And Dame Maura was also called to the bar at the Inner Temple. And Dame Maura will be speaking today on the history of colonization and the steps that have been taken in Britain in terms of bringing the laws up to date and free from the vestiges of the past. My next speaker is Sara Malkani. She's an advocate of the High Courts of Pakistan. Her practice focuses on litigation advocacy before domestic courts, as well as international human rights bodies. And she's the founder and chairperson of the Women's Lawyers Association. I'll be the next speaker, and Sara will speak on gender and the decolonization of laws relating to gender and family in Pakistan. I'll be the next speaker on commercial law. Al-Noor has already introduced me, so I won't indulge in any self-praise. Then I'm very pleased to welcome Dr. Amber Dar. She's an advocate of the Supreme Court of Pakistan, barrister of Lincoln's Inn. She's currently lecturer in competition law at the School of Law, University of Manchester, and a senior research fellow at the Center of Law, Economics and Society, University College London. And after Amber, Mr. Salman Akram Raja will speak. He's on his way, he should be here very shortly. He's an advocate of the Supreme Court of Pakistan with expertise and experience over several decades in all forms of dispute resolution and successful advocacy in several landmark cases before the High Courts and the Supreme Court of Pakistan. And it also gives me great pleasure to introduce our discussant today, Justice Qazi Faizi sir. He's a justice in the Supreme Court of Pakistan He was called to the bar at the Middle Temple. Justice Issa is well known for his strong adherence to the Constitution and has published extensively on Pakistan's constitutional law, Islam, and the environment. Once again, a very warm welcome to all our speakers today. Ladies and gentlemen, the format today of our discussion would be each speaker speaking on their topic, followed by Justice Issa, the discussant, summarizing all that has been said and giving his viewpoints. Then we shall proceed on a discussion between all the speakers. And finally, we shall leave the floor open for the audience for any questions on the topic at hand. So without much further ado, I would like to request Dame Maura McGowan to start her address today. Dame Maura.
Pakistan at 75. Salgira Mubarak, Pakistan. I am honoured and pleased to have been invited today. I'm also, I should tell you, a little bit anxious because it's very easy on this topic to say the wrong thing and unintentionally to cause offence. But the fear of causing offence should never stop this important discussion. Disagreement is a vital part of the process of developing law and all other social structures. And part of the ethos of this university is to train people to disagree with courtesy and intelligence. And that, I hope, is part of the debate that we will inspire today. Now, although I'm a judge in England, both my parents came from Ireland, and I was called to the Bar of Ireland as well as England. So I know a little bit about how a legal system comes to terms with the inheritance of another country's laws and practices. Having thought about the title of this discussion, I decided that actually I'm simply not able, fully or adequately, to define the term decolonisation. But to achieve it, if that's what you set out to do, will require a blend of principle and pragmatism. Change for change's sake is likely to cause uncertainty, and that is damaging to a legal system and a wider society. The law must be clear and certain. And if, as the introduction to this discussion suggests, laws are out of sync with the current world, then they should be updated. Whether it's because they are part of a colonial past or whether they're simply out of date. And if that updating means removing old laws, then you will also achieve decolonisation. But you will end up with laws that serve a modern society and serve it well. Because the law always needs to be able to deal with current problems. Criminal law in particular needs to adapt, and it must adapt to deal with the current behaviour, current trends in society. And so the expansion of the sale of drugs or the use of motor cars in the 20th century led to new laws dealing with drug supply or dangerous driving. And the expansion of modern slavery in the 21st century has led to the expansion of law on human trafficking. That's the way the law evolves, the way the law moves. Currently, in the criminal and commercial fields, we need laws to deal with cybercrime. That wasn't in the contemplation of anybody in this room 20 years ago, never mind 75 years ago. The Criminal Code of Pakistan was written in the middle of the 19th century, more than 150 years ago. So it would inevitably require to be updated, even if you wanted to keep it intact. the Constitution, drafted 75 years ago, has been amended a number of times because it was necessary to adapt to accommodate developments in society in order to remain relevant. And so, over the 75 years, Pakistan has become a signatory to the Universal Declaration of Human Rights. Article 10A of the revised Constitution underpins what we would now call the human right to a fair trial. But neither of those things was contemplated at the time the Constitution was drafted. So, as well as evolutionary changes, there have been very substantial changes to the criminal code in a way that is totally Pakistani and has completely abandoned the British approach. These developments are fundamental and clearly show a break with the past and an adoption of values as set out in the Constitution. In 1990, more than 30 years ago now, the code was amended as part of the process of bringing the criminal law into closer alignment with Islamic principle. In your old system, in our current system, criminal charges are brought by the state, who take full responsibility for the prosecution and the sentencing process, and they take that responsibility away from the victims. The views of the victims are considered but do not bind, and the state would never withdraw, for example, a homicide prosecution at the request of the victim's family, or require their consent to the form of punishment to be imposed. But the amendments in 1990 introduced that into your criminal code, and that is Pakistani law. That is not colonial. You have amended and changed the law to suit your own circumstances. But there will be areas of the law that will never change. Basic norms, natural laws, are followed by all established states. Not to kill, not to steal, are human basic norms. And inevitably, those laws in their most simple form will remain constant whenever they are drafted or by whoever they are drafted. Equally, there are now wider universal aims, commercial stability, prosperity, and that will mean adopting and adapting law from other countries in order to trade successfully, in order to litigate trade disputes. But if we go back to the original question, is decolonising law a question of form or substance, or both? Does the language you use in your courts matter or not? Does the way your barristers dress, your judges dress, the courts look, does that matter or not? Would changing the language, for example, mean a change of emphasis? That's perhaps a question for debate later, as I hope will be this next question. What is the effect on the way law is practiced and administered in Pakistan of the reality, which is that many of your advocates and your judges are trained and educated elsewhere? Can that change? Should that change? When I started to think about the question, my first thought was, well, I could simply say, keep the good and get rid of the bad. But actually, colonial laws are probably a mixture of good and bad. And post-colonial laws are almost certainly a mixture of good and bad. So the decision isn't quite so simple as what is good and what is bad. But more importantly, this decision should be what is relevant and what is adequate in a contemporary context. And whatever is adequate and relevant today must constantly be reviewed, because all law has to be kept under review to make sure that it remains adequate and relevant. Thank you.
Thank you, Deimora. That was very interesting, and I think this is a very good starting point in terms of taking the discussion forward. Welcome, Salman Saab. Thank you. It's all right. Okay. I would like to invite Sara Malkani now to speak on the decolonization of family laws in Pakistan. Sara.
Thank you very much. So obviously, it's a huge topic, but I'll just very briefly talk a little bit, so that will set the background for the more substantive discussion that I will have on the decolonization of personal laws here in Pakistan. So as Dame McGowan discussed, the legal system that the British established in the colonial era still very much forms the foundation of our criminal and civil justice system, with several amendments and reforms, of course, in the post-amendment era. So in a very obvious sense, then, decolonizing the law would mean diminishing, if not eliminating, the influence of colonial rule on our legal system, to replace it with a system that is more local or quote-unquote indigenous. But I think we can all see why this would be a hugely complicated task, not least because identifying what is local and indigenous for a nation state with as much linguistic, ethnic, religious, and cultural diversity as Pakistan would be extremely difficult. We'll have to answer questions such as whose local and indigenous values? Would these local values be based on the religions in Pakistan or the multiple traditions followed in Pakistan? And with multiple languages spoken within our country, which one would we adopt, or which ones would we adopt as the legal language? So the question of decolonizing the law opens up many of these questions. And so, leaving aside the practicality of an endeavor of decolonization, we must ask, is it even desirable to move towards decolonizing the law? And here I'll echo what Dame McGowan has said, which is that, in my view, blanket decolonization for the sake of decolonization would be a meaningless exercise unless we have some kind of vision of what the alternative should look like. And in fact, what is much more desirable is an assessment of each area of the law to see whether it is working or not. And if it is not working, why not, and how should it change? And so, to see how we can navigate some of these very complex questions, I will look at one area of colonial law as an example, and one that post-independence, post-1947, has gone through a form of limited decolonization. And that area of the law is what is known as a Muslim personal law. So before I go into a little bit of detail about what Muslim personal law is, I'll talk a little bit about how it originated. There'll be a brief walk through history, but I'll try to keep it as interesting as possible. When the British assumed control over large areas of the subcontinent in the 18th century, one of their endeavors was to bring about some uniformity in the laws and the legal system. However, even in these very early stages, there was there was a notion that there should be some areas of the law, especially those areas considered sensitive, that should not be, where uniformity and codification should not be imposed. And these areas were deemed to be areas related to family, so matters pertaining to marriage, divorce, guardianship over children, and inheritance. These were deemed to be areas that were too sensitive for the British to actually impose laws from the outside, and so very early on, these were supposed to be left to the religious groups and communities. So even in 1772, where you had the Warren Hastings judicial plan, which was the first large-scale attempt to establish a judicial system for most of the subcontinent, even that plan provided that suits related to inheritance, marriage, caste, and some other religious usages would follow indigenous legal norms, and those would be based on religion. So for Muslims, the law of the Quran would be followed. For Hindus, it would be Shastras. For Christians, their religious law, and so on. However, even then, the British soon came to realize that this would not work. It would be too problematic to leave these areas to the communities, because it may have surprised them to know that even these communities are not monoliths. So even within these communities, there is no consensus on what is the law. And there was not complete agreement within these communities on how issues pertaining to inheritance, family life, etc. were to be decided. So then what we see is, towards the 19th century, when there are another series of legal reforms initiated, there is a move towards custom rather than religion. And there are a series of regulations passed which say that in areas pertaining to family law, marriage, divorce, inheritance, etc., religion of the communities as well as custom will be followed, traditions, etc. But of course, again, you hit that problem of diversity. Whose traditions, whose customs? And of course, you run into the problem that customs and traditions are not static. They keep evolving and they keep changing. So you ended up with court decisions that were often ad hoc, that were often contradictory. There was lack of clarity on which sources to cite to, who are the experts when it comes to deciding what the law of a particular religion is, which sect within a religion should be followed. So you really had a lack of uniformity and a lack of consistency. And some attempts to deal with that included attempts, for example, to have experts try and establish authoritative texts on what these religious laws would look like. And just to give you an example of that, it was in 1905 that an authoritative text on Muslim personal law was written, which was called Principles of Mohammedan Law. And it was written by an expert called Dean Shah Fardoonji Mullah. And it was written in 1905, but even post-independence, it continued to be used as an authoritative text in Pakistan's courts to understand and lay down what is Muslim personal law. But we see when we get closer to independence that over time, as Muslim groups particularly developed stronger political identities and began to mobilize, there was a push to remove the additional influence of custom from matters pertaining to family law, inheritance, etc., and to ensure the primacy of religious-based personal law. And so what we have, perhaps the most significant law that comes about pre-independence is the 1937 Muslim the Muslim application of Shariat Application Act, the Muslim Personal Law Shariat Application Act of 1937, which lays down that for Muslims in matters of marriage, divorce, inheritance, guardianship and custody of children, it will be Muslim personal law that will prevail. And so come 1947, this is what we inherit. What we inherit is a framework that would probably best be described as Anglo-Muslim personal law. So it's accepted by some to be Muslim law based on Sharia, but it's very much the product of the colonial encounter with South Asian Muslims. And it's very much a political project. And that is what we walk into in 1947 and realize very quickly that it's not working. And we come to that realization when women groups in post-independence Pakistan come to realize that these laws are inadequate for the equal status that they seek to achieve. And the turning point really came in the early 1950s when then Prime Minister of Pakistan, Muhammad Ali Bogra, took on a second wife, which he was allowed to do under the family laws because it was law based on Sharia, which of course, as we all know, permits polygamy. There was an association, All Pakistan Women Association at the time, which comprised of women of prominent families who objected to this. They felt that it was demeaning that this should be permitted. And it was their mobilization that led to the first endeavor to bring about a reform in family laws in Pakistan. And this led to the establishment of what came to be known as the Rashid Commission in 1955, and it had the mandate to bring about a change in Muslim personal law as it applies to family law. And it really stemmed from this realization that laws that were based on a certain interpretation of Sharia were not granting women the equal status that they believed they deserved, especially in a post-independence Pakistan. However, the tensions were still there. So there was still a reluctance to move away from interpretations of Sharia, to move away from interpretations of Islam that nonetheless created these tiers, these gender-based tiers. So if we look at the mandate of the commission, it was, you can tell some of the tensions that are at the very foundation of this project. So it was mandated to answer the following question: do the existing laws governing marriage, divorce, maintenance, and other ancillary matters among Muslims require modification in order to give women their proper place in society according to fundamentals of Islam? So there is a reluctance to move towards, what you might call complete secularization. There's an adherence to Islamic values, but at the same time, maybe a need to bring these Islamic values in consonance with modern society, and especially with the demand for equality. And of course, these reforms ultimately led to significant laws, the codification of Muslim personal laws in the form of the Muslim Family Law Ordinance of 1961, and then eventually the Family Courts Act of 1964, which set forth a separate procedural mechanism for dealing with matters pertaining to divorce, custody, maintenance, and so on. And these laws were significant milestones towards the codification and stabilization of women's rights within a marriage. However, they did not go far enough. For example, these laws still do not recognize the right to marital property, and polygamy, which was one of the impetus behind the reform efforts to begin with, is still very much in place. And so at the same time, the religious right was not happy with these either. They weren't happy with the process of codification. They were not happy with the requirement that marriages be registered, and also that the secular courts be established. So in some ways, there was dissatisfaction from various political groups. And why I've put this forward as an example, and why I think that the endeavors of this commission are significant, is that we can view them as an attempt to decolonize these Anglo-Muslim family laws in light of a post-independence demand of equality, especially coming from women. However, the decolonization, quote-unquote decolonization process here itself yielded a contradictory result, because the state and even civil society was at that stage confused about what a post-colonial framework should be. Should it be, on the one hand, secular and rights-based, or should it, on the other hand, be religious? And of course, we know that this confusion persists to this date. And even more recently, attempts at decolonizing family laws have continued, and some have been successful. So, for example, we have domestic violence laws in all provinces of Pakistan. We also have some attempts to, we have had successful attempts in one province to reform child marriage laws and to modernize them. However, the implementation of these continues to be met with resistance. And so the tensions continue. I will just very briefly, kind of like to end with what is a way forward from these tensions that we see are persisting to this day, 75 years after independence, where the conceptualization of decolonization still needs some clarity. And maybe, again, this itself is a huge discussion, but one way in which maybe we can look at decolonization is to remember that post-independence and post-global decolonization, the field of what is known as international human rights emerged. And in the 40s, 50s, and 60s, a number of international human rights treaties came into force, and international human rights systems were also put into place. And Pakistan has signed and ratified many of these treaties, including the Convention on the Elimination of Discrimination Against Women. And so maybe the adherence to these treaties, which really came about in this post-colonial era, can be viewed as a movement towards decolonization. And reform efforts can maybe look to these treaty obligations as a way forward, especially when it comes to reforming areas of family law.
Sarah, thank you. That was very, very interesting. And I think what was very important was that you gave us a very clear chronology of how these laws came into being, starting from the colonial era itself. Ladies and gentlemen, the next topic is commercial law, and I shall be speaking on that. We do have, in Pakistan, there's a substantial corpus of commercial law, which is both colonial era, and then, of course, we have a lot of modern laws as well, regulating various spheres of commerce and financial transactions. Before I do that, I'd just like to, as a backdrop, give an anecdote from my time when I was law student at LSE. In my second year, I was taught by public international law by Christopher Greenwood, who later on became a judge at the ICJ. So I was used to writing very long-winded essays, in flowery language and, trying to impress everyone with my prowess over English language. So one day, my professor called me and he said, he took me to a side and he said, you write well, but you remind me of a Victorian gentleman from the last century, in a smoking jacket, smoking a pipe and waxing out language which is not really decipherable to people in the modern era. So please make your writing very concise. Thank God I did that. And then, of course, my pupil master, Dr. Parvez Hassan, is sitting here under his tutelage. It hopefully fine-tuned even further. So the question is, ladies and gentlemen, that are these colonial era laws, which I will discuss, which still form the corpus of our commercial laws, are they a relic of the past? Are they irrelevant? Or do these laws resemble a strongly built building with timeless architecture? It is up to us how we update this building according to modern requirements, since the foundations are strong and the architecture could be timeless. In my view, ladies and gentlemen, it is the latter, because Sarah has given a very good background on how these certain colonial era laws came into being, starting in the late 1800s. There was the Indian Charter Act of 1833, where the Indian Law Commission was formed for consolidation of laws. And then various common laws relating to commerce and economic activity were codified into law. Examples of such law were the Contract Act of 1872, the Negotiable Instrument Act of 1881, the Stamp Act of 1899, which relates to revenue, but again, directly governs commercial activity, the Registration Act of 1908, the Sales of Goods Act of 1930, the Partnership Act of 1932, and there's also the Arbitration Act of 1940, which obviously governs a lot of commercial arbitration in Pakistan. There was also a Companies Act of 1913, but now, of course, it has been updated first through the Companies Ordinance of 1984, and then ultimately through the Companies Act of 1917. Sorry, I beg your pardon, 2017. I was too stuck in the past. The question is then, there is the Companies Act of 2017, and we have a lot of laws in the last 22 years since the dawn of this new century, which have, regulated various fields of commerce and try to sync with the modern commerce and the modern requirements of transactions. But when we view these colonial era laws, they are still in place. They are the backdrop of our contractual relations, of our commerce, and they are still used, they are still interpreted by the judiciary, they are still quoted, they are still relied upon. So are they relevant? Firstly, for any law to be effective and good, and taking on from what Demora has said, number one, it has to be intelligible. It should be easy to decipher, interpret, should not be too esoteric, not just for the layman, but also for the lawyers. Secondly, it should be relevant for the time period, place, and the socio-economic environment. And thirdly, very importantly, which is tied to the second factor, the second point, with that, it should have systems in place for its smooth application and enforcement. So these colonial era laws which I referred to, are they intelligible? Yes, they're pretty much intelligible. Anybody who wants to read contract law, if they go through the Contract Act, they will be able to go through it and understand the concepts. Are they relevant for the time period, place, and socio-economic environment of 2022? Yes, to an extent, but they do need upgradations, and they have to be in sync with the modern realities of commerce and modern realities of economic activity. By way of example, if you look at the Contract Act of 1872, it's still in force in Pakistan today. It still enforces the principle of privity of contract, i.e. that the contract is between two parties. Third parties cannot enforce rights. We know that in other jurisdictions, even in England, third parties now can enforce rights in certain circumstances. There was the Contract Rights of Third Parties Act of 1999 in the UK, so third parties have been given certain rights. In the modern age, contracts are often exchanged through electronic means, mostly through email these days, through fax as well. The Contract Act has not made provisions for that. We have the Electronic Transactions Ordinance of 2002, which recognized communications in electronic form, but still a lot of work has to be done. Not many people are aware of that. The other day, I had a client who was based in Dubai, a Pakistani entity. They wanted to exchange employment contracts. They wanted to, I said, just send them over email. They'll sign them back, and that'll be it. They insisted that you call them over to your office, take those contracts out on stamp paper, and have them sign it. And I had to explain to them, that stamp paper is a revenue matter. It relates to payment of stamp duty. I don't think you really need to go through all that trouble. But they still insisted, so we did that. So a lot of awareness needs to be done, and that includes updating laws to that effect as well. Stamp Act of 1899, now that's a very interesting law, although, as I said, it deals with collection of revenue, stamp duty by the government, but it applies to a lot of commercial transactions. The Stamp Act is still using, every year there are amendments in the Stamp Act, but they just relate to the increasing or modification of stamp duties according to the various finance acts passed by the provincial governments or the federal government in Pakistan. Have there been any effective updating Not really. I think the last one was the concept, the provision relating to e-stamps, which was a boon for us transaction lawyers. Otherwise, we had to bring loads of stamp papers and print documents on that. But now we just have the e-stamps, which is very good. But apart from that, no substantial amendment. We are still using antiquated terms like pawn and pledge in security documents in banking transactions, whereas any banking lawyer would know that we have far more sophisticated security documents in place now in both local and international financing transactions. We are still stuck, with this whole issue of stamp duty for when a foreign lender is involved in the banking transactions. For local lenders, there are caps now of stamp duty. There are even exemptions under the recovery law regarding inadequate stamping of security documents. But for foreign lenders, we have to, we lawyers, commercial lawyers have to come up with inventive ways and means of how to avoid stamp duty. We ask the borrower to go outside of Pakistan to sign these documents and just hope and pray that they're never called into evidence in a court of law in Pakistan in the future. Why doesn't the government rationalize that? It will earn them good stamp duty. But nobody's willing to do that. In fact, the last amendment was in 2021, and there was a lot of focus on powers of the collector to seal premises and fines and imprisonment for non-compliance. Does that reflect a colonial era mindset? Maybe even more so. The state has the punitive right, the coercive powers, and also the right to enforce punitive measures, but it should also be complemented by facilitation of business and economic activity. We have the Sales of Goods Act, 1930, still used. What is a sale of good? How does the title transfer? But we are still stuck with the concept of what is called merchantable quality as an implied term in a contract to determine what is an acceptable quality of goods. Other jurisdictions have moved on. There's a concept of satisfactory quality in most countries, even in England in 1994. So, we still need to update that. But all is not bad. As I mentioned, the Securities and Exchange Commission of Pakistan have done a lot of amendments in the last 10 to 15 years. There have been so many laws. So we have, complementing, modern laws as well. One very good example of that is the Limited Liability Partnership Act of 2017. We still have on one hand one regime of the 1932 Partnership Act. But on the other hand, we thank God we have a Limited Liability Partnership Act. So a lot more, things like these need to be done for updating of these colonial era laws. And finally, the question that, or the point that colonial era laws should have systems in place for the smooth application and enforcement. Now, all these laws that I've narrated just now, their systems were set up over 100 years ago. We are now, as I said, in 2022, and there are so many things that can be done to update them. For example, land transfers can take place electronically. They're done in most countries. But in Pakistan, if you want to go and transfer property, commercial property or otherwise, it's still a process replete with landmines for the uninitiated. Why can't we, update something like that? In contracts, systems, DocuSign, for example, is a very widely accepted system all across the world. But still in Pakistan, we are still grappling with that, how to put that in place. I gave you the example of the employment contract just now. So in a nutshell, ladies and gentlemen, the fundamental point is that these colonial era laws that started from the late 1800s and all up to 1947, they were promulgated to their specific era. But I still think that they provide a very, very strong building block for their upgradation. They have the advantage of being intelligible. It is up to us how to update them, whether through amendments or through repeal, but using the same concepts for the modern commercial era. I believe that it is only through updating them on these lines that even mindsets relating to commerce and commercial activity shall change. It is a chicken and an egg situation, but I think in the present instance, the chicken comes first. If we update these laws, we create sufficient awareness, it shall create more modern mindsets towards doing business and commerce by still using these very strong building blocks. Thank you. Thank you. I would now like to invite Dr. Amber Da to speak on regulation. Thank you.
Thank you, Raza, and Assalamu alaikum, everyone. I must apologize for my voice. I think I sound better than this on a good day, but this was my gift from Pakistan when I arrived a few days ago, so please forgive me. I'll try to speak clearly. So when I was unpacking this issue for myself, I actually asked myself 3 questions, and I must admit I was wearing my academic hat as well, because I try to think sometimes only like a lawyer and sometimes only like an academic, but I'm trying to combine both in this conversation. So my 3 questions were, what is decolonization? What do I make of it? How is it relevant to what I call Pakistan's economic laws or regulatory laws? And third, what can be done about it? I mean, how can Pakistan decolonize? So these are the 3 questions. I will share my thoughts with you, and we'll see how we get on. So the word decolonization, as we've all mentioned earlier, first gained currency in the aftermath of World War II, when countries from Southeast Asia to Sub-Saharan Africa were gaining independence from the British Empire after centuries and decades of British rule. In this context, decolonization was about exercising sovereignty over their political, economic, and legal systems, and really the right to self-determination of the indigenous peoples. But this is not the only concept of decolonization that is currently in vogue. There is a new wave of decolonization, which I really come across as an academic working in the UK. We constantly hear about decolonization of the curriculum, decolonization of the university. So what is all that? Now, that is a concept that emerged in academia in 2011 in a conference in Malaysia. It was picked up in another conference in the University of Cape Town with the Rhodes Must Fall movement. Cecil Rhodes was a great colonial imperialist, came to the UK in protests at Oxford University. Students started questioning, why is the curriculum all white? Why are we only studying from, white men, with apologies to all the men in the room? Throughout UK academia, there was a wave of decolonizing the curriculum, and I don't know how successful it is or how even deep it goes, but certainly it's now across the board in all areas of study. So the differences between these 2 versions of decolonization are obvious, and I don't need to go into them. But at the core, there is a similarity, there's a commonality that binds them, and that's where I'm really interested. So both versions of decolonization are seeking to redress a power imbalance. Now, the traditional version, the power imbalance is obvious. It was between the periphery and the core countries, give us our rights. The second one, it's a little bit more subtle. It is the power imbalance within different groups coexisting in a country. But eventually, it is about redressing power imbalances in where they exist. So this brings me now to the second question, and I'll dwell on this a little bit longer. What does this have to do with the Pakistani regulatory laws? As Raza has mentioned, a lot of these regulatory laws are actually new. And certainly, Pakistan became an independent economic entity way back in 1947, so wasn't it decolonized in that moment? So when I was, I'm interested in this topic anyway, and I was looking into the economic history of not only of Pakistan, but also of a lot of post-colonial states. We were born in an increasingly decolonizing world, but there was a wave of institutions that were replacing the old colonial structure, and these were the multilateral agencies, born around the time that World War II infrastructure is being dismantled, the imperial infrastructure is being dismantled, and there's a wave of multilateral agencies. They were all housed in what we now call the global north, and they had as their focus the need to create or to foster economic interdependence, and again between the core and the periphery, but now they were using new words. It's global north, global south, or developing, developed. There was a terminology difference, but really the essence was the same. So from its very inception, from its very birth, Pakistan fully embraced this movement, international movement. So in 1950, within 3 years of its birth, it becomes a member of the IMF and the World Bank. A few decades later, it was one of the original signatories of the World Trade Organization in 1995. And over the years, it has signed several standard form. What I mean by standard form is not really negotiated, but sort of the standard paper that you pick up and sign, bilateral investment treaties with a lot of countries. And the idea was, this will encourage foreign investment. I would love to talk about how that ended, but that's for another day. We won't go into it today. The result of this web of interdependence, in which Pakistan was really keen to be part of, was actually Pakistan's dependence on the World Bank, the IMF, and the WTO for its economic policy, for its economic prescriptions. And it was as part of the World Bank's second-generation reforms that were introduced in Pakistan, and the IMF was part of it as well, in the late 1990s, that the idea of economic regulation, which had originated in the United States back in the 19th and 20th century, was transplanted in Pakistan. In the US, it had grown organically. They were responding to the difficulties they were facing with the judicial system, the facilities they wanted to provide for contracting parties or for the big business. So there was an organic foundation for this development in the US. But in the Pakistani context, it was designed almost entirely behind closed doors. And you can see by the number of ordinances that were passed to actually bring about the regulatory state. So it was introduced in Pakistan through what we call top-down institutions, and without much stakeholder consultation. And the rationale, I used to work in Pakistan at the time when some of these laws were being debated. And one of the rationales was, people won't understand, somebody will try to scuttle the process, so this is the best way to do it. Again, not arguing right or wrong, but that is the way it happened. Very soon, we saw key economic activities brought under the control of regulatory authorities. Raza has mentioned the SECP, of course, one of my favorite haunts in the past as well, but also the CCP, the Competition Commission of Pakistan. There's NEPRA, there's OGRA, there's PTA, and there are many, many more which are PEMRA, for instance, non-economic, but nevertheless very important. What is very interesting, and I actually did this exercise at one point, I picked up all these laws, and they're very, very similar. You can almost trace their common origin. The mandate is different. Obviously, they're dealing with a different issue. The structure is broadly similar, but allows for some difference. But it's definitely coming from the World Bank prescription. We all follow what we call the single integrated agency model, which is prevalent in the EU and which we've borrowed as well. Where the government really makes its presence felt is in who can be appointed and who can be removed. So in all these laws, and I did this, I placed them side by side, the appointment is always in the remit of the government, and the removal will be on the recommendation of the government. So I thought to myself, we were really interested not in the design of a regulatory state, but in controlling it. As long as we control, and I say we broadly for Pakistan, as long as we control who is appointed and who is removed, we can control what they do. And that's where, to me, it seemed that our interest lay. So that was one issue. The second area, which I think has caused a lot of damage, in my view, was not really paying attention to how this transplanted system is going to interface with the pre-existing system. Even when the organs are transplanted, there's some diagnostics tests done to see whether this kidney is going to work in this body or not. But I think we didn't really do those diagnostics tests. World Bank tells us it will work, and we demur a little, but we broadly accept it. World Bank knows best, because they've been to other countries, so of course they can tell us. So a very interesting example against an area where I've spent a lot of time researching is the Competition Commission, the complicated history of the Competition Commission of Pakistan. The first ordinance, and again an ordinance, so behind closed doors, I can go on for this forever, but I won't. It said the Competition Commission is the first-tier authority. It's going to decide what the competition matters are, and then the appeals will lie to the Supreme Court. Now, what they failed to anticipate is this doesn't agree with the Pakistani constitution. I think Salman Saab knows about this very well. We were both in cases at the time, arguing against the Competition Commission. That led to a lot of problems. It overburdened the courts with countless constitutional petitions. They still haven't been decided, by the way. I mean, the Lahore High Court had a decision in 2020, October, still pending with the Supreme Court. Let's see what happens. But the petitions were filed back in 2009. But the courts were completely overburdened. That's one drawback of something like this. The Competition Commission, despite its best efforts, which I think it made, was absolutely moribund. Couldn't recover any penalties because there were stay orders pressing against it. And I think it gradually made it a little bit irrelevant. I hope there are no Competition Commission officers here, but I think it gradually became a little less relevant to the economic society. But I think the biggest tragedy, the biggest sort of casualty of this was Pakistani economy itself. Because here was a law with good intentions to create a level playing field for the different players in the economy, to get rid of cartels, get rid of abuse of dominance, but what do we have? Nothing. We continue as before. So big cartels, again, sugar and wheat, this has come up in the news in the last couple of years, they continue unchecked. Okay, so all this is the doom and gloom scenario, but what can we do about it? How can we decolonize? We are not now colonized by the British, who've long gone, but we have imposed this certain colonization on ourselves by acting like the periphery that accepts everything that the core offers to it. So before I suggest what may be done, I'm absolutely vehement about what must not be done. And I think I'm in agreement with everybody else who's spoken here. What must not be done is reinvent the wheel. There is absolutely no sense and logic in doing that. Drawing up laws from scratch for some imaginary original that doesn't exist anymore is pointless at best. In fact, I would go so far as to say that it is not only appropriate, but it is necessary that Pakistan borrow its laws. Because there's wisdom, there is thinking, there is development, there is, the evolved economies have thought about these issues for a very long time. We benefit from learning from them. But what is critical is that we contextualize these laws for our own domestic reality, whatever our pre-existing system is, and for our aspirations. Where do we want to go? We seem to be unaware of our reality, or at least we put it to one side, but we are clearly, I think we somehow don't develop our own aspirations economically. We are quite happy for World Bank to tell us, or IMF to tell us what our aspirations should be. So again, an interesting example of how that contextualization may take place. I can take you to India for a brief journey across the border. India had a very similar Competition Act, 2002, so it's 5 years before us. Exactly the same implementation trajectory, the Competition Commission of India, CCI, and appeals to the Supreme Court. Within months of this law being passed, and before the Competition Commission of India could be made operational, Pakistan, of course, made its CCP operational within a week. But before they could do that, a citizen, filed a petition before the Supreme Court. He was Mr. Brahm Dutt, so this is famous as the Brahm Dutt case. And he said that the powers of the Competition Commission are contrary to the principle of separation of powers, which is provided in the Constitution of India. Now, we have the same principle of separation of powers in the Constitution of Pakistan. The Supreme Court took up the petition, but before the Supreme Court could decide it, the government itself withdrew the matter and said, we'll amend the law. And so they amended the law, and not just they created an appellate tribunal, so which would be the adjudicatory body. So no longer will the Competition Commission will be the judge, jury, executioner, which it is in our context. They created an appellate body. They also prescribed more objective rules for who can be appointed and who can be removed. So this sort of made the commission more independent. So that's one example. And it was only once they had done that they made the CCI operational. And the CCI has actually been able to recover some, there's some penalties are not recovered because matters appealed, that's perfectly legitimate. But I think by and large, it is functioning quite properly since 2007. So this was the issue of contextualization, and it's absolutely critical, but it addresses only the first aspect of decolonization. It addresses our power imbalance against the core, and it creates more independent space for ourselves, and that's, of course, very important. But the second aspect of decolonization, which I call, creating more, the sort of correcting the imbalance within the community, within the country, within the polity. And to do that, what you need is representation from the different groups whose economic lives we are governing. Pakistan, as I've mentioned, decides a lot of its economic regulatory laws, especially because they're considered technical and therefore not easily accessible to the average person. They're decided behind closed doors. They're introduced as ordinances, and the ordinances are then ratified without much debate at all in Parliament, if they're ratified. I mean, we were stuck with the Companies Ordinance 1984 till 2017. You know, we have other extra constitutional means of also making our ordinances last longer than the Constitution of 4 months. So representation then, I'll take you again to India briefly for showing the sort of significance of representation and what happens. I'm sure everybody's heard about the farm laws. I mean, impossible not to. It was just happening across the border. So in 2020, India passed 3 farm laws as ordinances. So I always joke, India is learning from us, that if the law is complicated, just pass it as an ordinance. There are 3 ordinances. I think it was May 2020. Farmers' protest erupted throughout the Punjab. But the government was steadfast, and in September 2020, just as the ordinances were about to lapse, they ratified them and enacted them as acts of parliament. So I won't take you to the names of those laws, but they were collectively referred to as the farm laws. Now, the Indian government had good reasons for doing what it did. It was acting under the guidance of the WTO, and its aim was to increase food production by inviting big agribusiness into India, by allowing for contract farming, and especially for allowing the trade in food products on market prices rather than on subsidized prices. So I think anybody, especially in a business school, you would hear immediately, this is good neoliberal economics coming in, and India was following that. Farmers complained. Farmers had a different point of view. So they said, this will reduce our income. We will end up in one-sided contracts. I mean, who can take a big agribusiness to court, which might even have a clause that it can only be, all disputes should be sorted by arbitration or sent to the ICC? Which farmer is going to do that? And they said this will reduce our ability to feed ourselves, but this will also be terrible for the environment because there'll be, biodiversity will be affected and water table will be affected, so all those things. But one of the things which struck me, they kept saying, our views have not been taken into account. We as farmers are closest to the land. We understand what is happening, and nobody consulted us. These laws were made behind closed doors, and they've been foisted upon us by the government. So standoff continued for a year, but eventually, I mean, the Supreme Court also passed a judgment in favor of the government. So it was really quite, the entire institutional infrastructure was against the farmers, but eventually the government had to take it back. So the laws have been withdrawn. I don't think it means that the laws will never be enacted, but I think whenever they are enacted in the future, I think there's a very strong likelihood that farmers will be included. So, I asked myself, why could India contextualize and respond to the call for representation and we couldn't? And I think the credit in that doesn't go to the government, really, or even to the state and the judicial institution. I think the credit for that goes to the citizen groups, who were informed, educated. I had the great privilege of speaking to some farming leaders because I was sitting in the UK. They were comfortable in speaking to me. I invited them to speak to my students as well. And they were, they were impressive because how well they understood their agricultural history and where they wanted to go with it. So it came from the citizens. Even in the Competition Commission, when the infrastructure of the commission was challenged, it was the citizens coming to the fore. And they were steadfast in defending themselves before the might of the state institutions, which we often don't do. So then I think the final word is that if we really want to decolonize, and by that I mean if we want to be more in charge or more independent in charting our economic trajectory, we really have to go through bottom-up participatory institutions. We have to aggregate the knowledge, the tacit knowledge that exists within the country, bring it forward, allow the laws to be informed by that, and risk disagreement. That's the worst risk we have. But I think something beautiful comes out of all disagreement, and I think if Pakistan is able to, and this is really a call for democracy, and the continued call for democracy, which India has had and we have not had, I think we will only then be able to decolonize ourselves in both senses of the word, not just against the core periphery. Thank you.
Amber, that was very interesting, and I think the key takeaway from that is, and we will discuss it later on, is that it is necessary that Pakistan borrows. There is no harm in borrowing its laws and contextualizing them for our own realities. Our next speaker, Mr. Salman Akram Raja, he will speak on property laws in the context of decolonization. Salman sir, please. And your slides are also ready. The slides are also, we'll put on the slides.
Well, if you can put them up, I don't know, you can put them up here.
I've already arranged for that.
They would come up here?
They
Okay,
would come
fine,
up.
that's good. Okay, now I was proposing to talk about, the Land Acquisition Act that exists in Pakistan today, and that clearly is a colonial era construct. The Land Acquisition Act of 1894 is the law that we have today. We'll go back to that later. No, we don't need to put these up just now. I'll ask for these later. Just leave this where it is. Yeah, that's fine. Now, this is the Indian Act, which I was going to come to later on. But the story of the Land Acquisition Act of 1894, I think, encapsulates a lot of issues that have been raised by Dame Mora, by Sara Malkani, and Dr. Dar. What do we really mean by decolonization? Okay, the colonial project formally ended in 1947. But what have we had since then? Has decolonization really meant a deepening of democracy, of inclusion? So if we think of the colonial project as an extractive project, as an alien project, as a project that sought to keep the masses out, have we reversed that project in some meaningful sense since 1947? And I would submit that the history of the Land Acquisition Act really captures a lot of these issues and where we've headed since 1947. So if we look at the original Act of 1894, the object clearly was to enable the state to acquire land for purposes that were described as public. So the key word in 1894 was public purposes. And if you look at the original acquisitions in the 1890s, the early part of the 20th century, those acquisitions really are for roads or dams or other projects that you would readily recognize as public projects. But then we see that as time goes by, through the 1930s, there is an expansion through amendments made to the 1894 Act. The concept of public purpose has expanded to include dwellings for workers. Now that's again a fairly limited expansion. Dwellings for workers are added to the concept of public purpose. That if you are running a business and you need to construct dwellings for your workforce, you can ask the state to acquire some land in order to provide homes to your workers. So that comes in. Now, after 1947, we see a set of amendments, particularly through the 1960s, our so-called decade of development under General Ayub Khan, which we often look back, in mythical terms as this period when Pakistan was going to take off and so on. Now, what we see through the 1960s is an expansion in the power of the state to acquire land under the Land Acquisition Act of 1894. And the acquisition clause is amended to add that land may be acquired for a public purpose or for a company. 2 words added, or for a company. Now suddenly the whole nature of the law and its effect and purpose in society changes. It now becomes quite clearly and quite patently a law that the powerful can employ, can petition the state to use for their benefit. And of course, the rubric was this is going to cause industrialization in the country, it's going to create jobs, and the country will take off. So with this as the working rubric, if you like, these words are added, and we embark upon an era of land acquisition for setting up industry in the country. Now, people are removed from their land, farmers are removed, the landless are removed, and we often forget that the landless also derive sustenance from the land that they're occupying, even though they might not have title. And I'll come back to this in a moment. So we embark upon this period of forced, as if it were, industrialization through displacement and exclusion of the already weak in society. And this is hailed as economic progress. The GDP figures start going up, the export figures start going up, the decade of development is underway under General Ayub. And lawyers like myself have a field day. We go out and we advise companies that are engaged in this acquisition through the power of the state. And this goes on, and is going on to this day, by the way. But then it acquires a different hue through the 1990s, as if it were, and later. Now, the companies that can acquire land include housing development companies. So the great, will take no names, the great housing or land development empires come into existence primarily because of the Land Acquisition Act of 1894. So if I'm somebody who says that I'm a great developer of housing societies, I can go out and I can create lakes in Gujarat, and I will go to the state and I will say, acquire this land for me, which you all know, or I'm presuming we know, is acquired at the rates that apply to rural land. And rural land transactions very often are not really transparent transactions. People transact land and they put some figure in the revenue records as the consideration paid. So what happens is that this gives the housing society developer a windfall every day of the week. You go out, you acquire land through the Land Acquisition Act for a pittance, and you immediately start selling files by declaring that this is going to be the next whatever town, right? Now the next whatever town, the files of the whatever town sell for 1,000 times, per canal that you've actually paid to acquire the land through the Land Acquisition Act. So this is the basis of the great housing society empires that we see today, the Land Acquisition Act. So what started off as a colonial era law meant for acquisition for a public purpose, in the post-colonial era becomes an even more extractive law. It becomes a law that the state and the elite use to plunder, for no better word that comes to mind, the citizenry of the country, the have-nots. So this process is still going on as we speak. And I'll come back to it, what it means for the rubric that we are decolonizing our laws. Various other laws have already been mentioned, the changes to the criminal code, the family laws, the CCP and the Companies Act. Each one of these I've had some engagement with, and I'll make very brief remarks about. But the Land Acquisition Act, I suggest to you, is a fundamental law that has tilted the balance, if there was a balance, further away from the weaker segments of society and handed power to the state and the elite that work through the state. That was never maybe the intent when the law was created, even in the colonial era in 1894. So this has gone on. Now, what we see happening across the border is very instructive. You must all have heard of the Narmada Dam controversy. So a large dam was to be set up in the 1990s. This is the Manmohan Singh era of liberalization, of embracing deregulation, and so on. Now, in that era, the Narmada Dam project is announced, and with it, the Land Acquisition Act is put into action to acquire large tracts of land in order to set up the dam. And that results in displacement of thousands of people, hundreds of thousands of people from their villages and their homesteads. And this leads in India to a very major agitation, somewhat like the farmers' protests, but even at an even larger level. And it finds voice in the figure of Arundhati Roy. Now, you need a champion, very often. So Arundhati Roy takes up the cause of the Narmada displaced people. And she writes about it, she talks about it, and Arundhati Roy being Arundhati Roy, she talks like nobody else can talk, and she writes like nobody else can write. And she takes matters to the courts, and ultimately, before the Supreme Court of India, She's convicted of contempt of court because she tells the court that the court has become an agent of the extractive state, and the way the law has been interpreted through the decades has done nothing but to exclude the weaker segments of society. So the conviction happens, Arundhati spends some time, I think, she actually goes to jail, and but it has an impact. The movement that Arundhati Roy and the others who agitated around the Narmada Dam were able to unleash results in a very major political dialogue, the kind of dialogue that we never have in Pakistan, that Dr. Dar was referring to. And all parties across the political divides get involved. And they frame the Land Acquisition Act of 2013, which we have up here. So the Indian Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act of 2013 comes into existence. Now, this is a fascinating piece of legislation, and it bears the marks of the political dialogue that preceded the enactment of this law. Now, if we were to just go through the table of contents a bit, you'll see, can we go down a bit more? Just hang on. Now, this starts with a social impact assessment study. So for the first time, what this law is saying is that, look, if you're going to acquire land somewhere, you have to not just look at the value of that land, what the going market rate is, and say, here, we'll pay you that market rate, and it is our sovereign right to acquire your land. Prior to that, you have to convince, and there's an authority created for that, that the acquisition is going to be socially beneficial. So a social impact assessment study has to be carried out, which will look at the rights not just of the landowners, but of everybody who lives on that land. So the carpenter, the mochi, the lohar, all of them who derive their sustenance from being part of a community that lives on that land. So the Land Acquisition Act originally, and as it exists today in Pakistan, is simply about paying compensation to the landowner. What about the entire community that gets displaced when you build something like the Narmada Dam? So this is where that conversation becomes apparent as a legislative measure. So the social impact assessment study now becomes the heart of the acquisition exercise. Can we go down a bit more? So you bring in experts, they look at all of this. Then very interesting here is the concept also, well, let's just run through the table of contents and then we'll come to some particular sections. So the assessment is carried out, the assessment also lapses. You can't just say we carried out an assessment and then leave the acquisition for an indefinite period of time. You have to then, based on that assessment, carry out the acquisition within a period of 12 months or the assessment becomes irrelevant. A new reality, a new social reality emerges. Can we go down furthermore, a bit more? Okay, now with that, look at this. Once you've done the social impact assessment, and you'll do the award to pay the landowners the just price for their land, you also have to issue a second award, which will follow what is called the preparation of rehabilitation and resettlement scheme by the administrator. So people who are going to be displaced from that tract of land, you are not going to just give them money. The money will obviously only go to the landowners, but everybody who's going to be displaced from that land has to be resettled. Because on any given tract of land, the landowners are few in number. Those living on that land are far greater. So the Land Acquisition Act of 1894 is colonial in the sense that it has no sense of the lives of those living on land apart from the landowners. It is a landowner-centric law. So this law says that no, everybody's lives will be examined, and there will be two awards. One will be the award for payment of money to the landowners, and the second award will be the award for the rehabilitation and resettlement of everybody who's going to be displaced from that tract of land. So can we just go down a bit? So they'll be either paid money or they will be provided little tracts of land to farm if that is what they do, or they will be provided small homes somewhere else. Because very often, because these are landless people, they're not going to be compensated. So how else do you compensate them for the disruption of their life? Can we just go down a little bit more? Yeah, we'll just run through this. So the Rehabilitation and Resettlement Award is an integral part of this law, along with the Social Impact assessment. I'll just leave it here for the time being. Now, when we look at the details of this law, you will see public purpose has been very narrowly defined. Now, public purpose actually means public purpose. Maybe I can just read a few lines. What is public purpose now? So after 100 years of misuse, the agitation that followed Narmada, the Narmada Dam, has resulted in a democratic process and intellectual, I would say, a remarkable intellectual input, which has resulted in a law which now I would submit is a law that takes into account the entire ecosystem disrupted by a land acquisition. So the public purpose is narrow. I'll not go through the whole thing. It says that activities listed by the government in notification number so and so, but excluding private hospitals, private educational institutions, and private hotels. So the private sector has been kept out. However, there is a provision here which says that for private companies, if land is to be acquired, it may only be done in the following circumstances. And I read, for private companies for public purpose, as defined in subsection 1, provided that in case of acquisition for private companies, the prior consent of at least 80% of those affected families shall be obtained. So the company has to go out and it has to obtain the consent of at least 80% of those who are going to be affected in that area. Only then can they go to the government and say that, look, we have these 20% pockets left. Can you please do the acquisition for us so we have a contiguous tract of land? So you've given voice here to the landless and to the voiceless. The Land Acquisition Act has no visibility of the landless. So the landless here become visible in this law. So this, I would submit, is a fine example of a decolonized law. We started with the law, the Land Acquisition Act of 1894. In Pakistan, it has not only continued, its extractive nature has deepened. And in fact, now if we come to a law in Pakistan, now while this law was being enacted in 2013 in India, we were enacting the DHA Act 2015. Kindly, if we can put up the DHA Act 2015. 2 years after this act, and if we can go down, yeah, kindly. Now this is the Defense Housing Authority Act, Quetta, which is kind of similar to all the Defense Housing Authority Acts, but this is their most evolved form. Can we just go down a little bit further? This is 2015, mind you. Just hang on, yeah. Okay, now just look at this. They frame a law which says it extends to specified area of Quetta and other districts of Balochistan. It covers all of Balochistan, okay? And it creates an authority. Let's look at what this authority is that this law creates. Can we go down a little bit, please? Hang on. So an administrator shall be a serving or retired officer, not below the rank of brigadier, duly appointed by the Chief of Army Staff, who shall perform such functions as may be assigned to him by the governing body. Then we go down. The concept of authority is very interesting. We'll come to that. Who are the members of the authority and the governing body and the executive board? Let me just, dispel the suspense. They're all army officers, serving army officers. So anyway, let's go down a little bit. Just look at the concept of a controlled area up there. Can we just go back a little bit? Means area notified as such by the authority within the province. So the authority is a bunch of army officers. They can, notify any area as a controlled area. Let's go down a little bit. And this is the province of Balochistan we are talking about. Specified area. Now this is important. Thoda sa, can we raise this a little bit so everybody can read? Specified areas means all land that may be purchased or procured or acquired by or leased to the authority in any area of Quetta and other districts of Balochistan as may be notified by the authority after the commencement of this act. So after the commencement of this act, the authority can express, to me, this is what this clause is saying, can express an intent, a desire to acquire or lease land in any part of Balochistan, and that land becomes a specified area. Now let's go on a little bit. Hang on. Yeah, kindly go on. Now, management. The governing body shall consist of the Commander, Southern Command, Quetta. Nice. The Adjutant General, representative, ex-Adjutant General's branch, General Headquarters member. Okay, they've got the Chief Secretary. The poor man will sit there in front of the Corps Commander and the Adjutant General, and so on, okay? So he's also there. Anyway, so let's just go down a little bit more. Now, what this law does is, I mean, we can go through the whole thing, and it's not a very long law, but let's leave it for a moment. What it allows this authority, consisting of who you've just seen, is to actually initiate the land acquisition proceedings itself. Now, the Land Acquisition Act of 1894 requires an application to be made to the government, the provincial government. If you are a company, you have to apply to the provincial government. The provincial government then authorizes the land acquisition collector to initiate the process, and so on. Now, this law gives the power to the authority itself to implement all parts of the Land Acquisition Act without having to go back to the provincial government or without having to engage anybody else. And it can acquire land in any part of Balochistan, okay? And for whatever market value it will determine as the fair market value. So this is where we've headed. So 2013, we see what happens in India. This is 2015, Pakistan. Now, the Balochistan High Court strikes down this law, says that, look, it is for various reasons, but one of the arguments that they make, there are some errors in that judgment, but their main thrust is clearly correct, that you cannot give this power to acquire any part of Balochistan to this authority consisting of these 4 individuals that, on their sweet will, they can identify an area as a specified area and go and acquire it. So how can you do that? So the Balochistan High Court strikes down this law. DHA, of course, files an appeal, and the Supreme Court suspends the judgment striking down this law. So as we speak, this law remains in force. And the Supreme Court, having suspended the judgment, will, I'm sure, hear it at some point. Maybe after August 2023, I'm hopeful, sir. But that is where things are at the moment. So the point to be made here is that why these 2 different trajectories? So we've always, I would submit, at the best of times, had a hybrid state. And you can see all the marks of that hybridity here, as opposed to some kind of genuine democratic process engagement across the border. Okay, they've not turned out very well in terms of their, intolerance that we see, but at a very different level, the democratic dialogue continues. Despite the Hindutva and all, the farmers were able to, initiate a democratic conversation and get it somewhere. So the 2 trajectories tell us that the decolonization of laws in a meaningful sense is not going to happen unless there is deepened democracy in the country. And along with that democracy, unless there are professionals, because these laws require an intellectual engagement and intellectual input of a very high order. The people who've drafted the Indian law, they've written books, by the way, they're professors, and they've explained how they went around the world looking at experiences with land acquisition in Latin America and in Africa and so on. So an immense amount of collected wisdom was brought to bear in the drafting of the Indian 2013 Act. Now, these things don't happen behind closed doors with a committee set up, like Dr. Dar pointed out, the competition law of Pakistan, for instance. Now, if I could interject with a personal recollection, I was a member of that committee set up by the World Bank to draft the Competition Act. And so this was remarkable. There was this very senior person from the World Bank, and they had engaged a competition lawyer who was Italian from the EU, and they then co-opted me as the 3rd member of the drafting committee. Now, after 2 weeks, I had a falling out with them, and for exactly these reasons, I told them that, look, you cannot just pick up a European law and implement it in Pakistan. We have a constitutional framework. There is this idea of separation of powers between the executive and the judiciary. So the powers that you're giving to this competition commission, to my mind, are clearly judicial in nature, and you cannot do this. And I started reading out to this gentleman from the World Bank, our constitution, Article 175 and this and that. And you know what he did? This World Bank officer, he actually grabbed the constitution from my hand. We were sitting across the table in the World Bank building in Islamabad. He actually grabbed the constitution from my hand, and there was a dustbin. He threw it in the dustbin. He said, what are you telling us? We are competition lawyers. We are not constitution lawyers. And at that point, I stood up and walked out. So that was the end of my engagement with that drafting committee. And 3 weeks later, they drafted the law that we had, which I then immediately challenged in court on behalf of the cement manufacturers, I might add, and got the stay order that you're talking about. And this was in 2008, 7, 8, 9. So I mean, this is how lawmaking happens in this country. So we have actually, at a very deep level, given up both on the democratic process and on relying on whatever intellectual input, intellectual ability we have in this country to frame laws that in some meaningful sense are decolonized laws that actually engage with our circumstances, that actually recognize what our larger constitutional aspirations are in terms of the independence between the judicial function and the executive function and the lawmaking function. So we really need to start taking our constitution seriously. We need to start taking our lawmaking seriously for it to become decolonized in any meaningful sort of sense. If I could have one more minute, So I've just come from Islamabad, on Friday, having argued a case before the Supreme Court, which in some respects, again reflects the issues that we've been talking about. And this was about, the rights of what are called workmen in our labor laws. Okay, so you've got a category which is really essentially the unskilled personnel in a business. So the law takes care of them. The law says that if you've been working on a permanent post for more than 90 days, you acquire the status of a permanent workman as opposed to a temporary workman. And you have certain rights then. The law gives you the right to a gratuity. Now, what is a gratuity? It is your last drawn pay multiplied by the number of years that you've been in service as a workman in an establishment. Now, the case that I was arguing happened because last Sunday, somebody, one of these trade union friends sent to me somebody called Chaukidar Riaz. Now, Chaukidar Riaz has been working for, I have no qualms naming the employer, PTCL, since 1992. This is the Pakistan Telecommunications Company. And he has been a daily wage worker for 30 years. They've kept him as a daily wage worker. He's illiterate. His salary today is 17,500 rupees below the minimum wage. His accumulated, they said, we'll not give you gratuity, we have a provident fund scheme. And his accumulated provident fund after 30 years is 10,000 rupees. And he's about to retire next year after all these years in service. And it turned out when I started looking at this, that this is actually not an exception. This is the norm across the board. So what we did after 1947, our decolonized laws, we had a number of laws that were meant to empower the servant. So the colonial concept was that of the master and servant, that the master decides the terms of employment of the servant. It's a matter of contract, and you are free to bargain your terms. So if you are an illiterate peasant from Swabi, you sit across the board with your employer and you negotiate your terms, and this is an equal bargain. So you settle the terms of your employment. Now, the decolonized law says, no, the law will come in and will say these are the minimum rights which are not negotiable, not to be bargained. You, Mr. Employer, have to give your workmen these rights as a bare minimum. So the law is there. On the statute book, you've got the Standing Orders Ordinance of 1968, and there's a whole set of laws, the Factories Act of 1934, and so on. But all of these laws are there on paper, but the reality is the life of Chaukidar Riaz. And he's not alone. I would submit he represents the hundreds of thousands of industrial workers across the land. So any employer who thinks he can get away with it, and most do get away with it, will do this. Keep him a daily wage worker for 30 years. Who's going to come and ask? Which lawyer is he going to engage to go and petition before a labor court, and then a labor appellate tribunal, and then writ petition the High Court, and then the Supreme Court? Now, this particular Chaukidar had actually done this, and he'd lost everywhere, of course. Okay. Now, I'm hopeful we'll win in the Supreme Court finally for him. We've had 3 very good days. But it just so happened that he turned up, and I decided to take up his cause and take it to the Supreme Court. But what happens out there is really the extractive state, the state that we see at work in land acquisition, also at work in denying the weakest in their existence as workers their basic rights. So we have a state which is extracting at every level, whether it is land, whether it is the labor of the weakest segments of society, and all of this is happening because we are not caring enough. We do not have a deep enough democratic process. So the decolonization urge has to be a democratic urge. Thank you.
Salman Saab, thank you. This was very, very interesting. I think the takeaway from this is that any decolonization has to be democratic, has to have the input of intellectual ability, and as Amber has said, it has to contextualize for the local environment. Ladies and gentlemen, so the speakers have spoken. We've given our respective viewpoints. May I request the discussant, the Honorable Justice Qazi Faiz Isa, to respond to all that we have said.
Assalamu alaikum, which means peace be upon you. The organizers have very strategically placed an Irish lady and a lover of the Irish on two ends of the spectrum. An aunt of mine, my uncle married an Irish woman, so there is a connection there. Never went to Ireland, nor to Northern Ireland, but loved the Irish humor. Still love Irish music, Van Morrison, Sinead O'Connor, Cranberries. I mean, without Irish music, I think English music will be half dead. And of course, Irish authors. They say that the greatest English authors are all Irish. I don't know. And what Raza said about writing long, complicated things, which he probably copied from an Englishman. An Irishman said, sorry, I'm writing you a long letter. I don't have the time to write a short one. So George Bernard Shaw, I think that was that. So now I'm placed in a slightly awkward position. Laws, I cannot really comment upon them because it may come to me at some stage. So that may not be appropriate. There is already one case pending here. There's a potential another case pending there. And of course, Amber, I take great pride in because she worked with the firm which we had set up and now is hopefully teaching good law to Englishmen. If you think it is ironic that we are speaking in the English language while discussing decolonizing, well, I leave it there. I won't any further comment on that. Since I can't talk about pending cases, since I can't talk about the laws which may be challenged before me, what should I talk about? Let's talk about the larger subject, the structure. What did it mean to decolonize? Literally a handful of Englishmen came and ruled over the subcontinent of the then India, which formed Pakistan, then East Pakistan, India today, so Bangladesh, Burma, all over the place. So how did they manage to rule this large area of land? They were extremely shrewd and clever. They started something called the Sardari, the Nawabi, the Malaki system. What was that? They said, hey, hang on. Now, Balochistan, and I'm really now concentrating on the areas, my own area primarily, Balochistan, the Khyber Pakhtunkhwa province, which then used to be known as the Northwest Frontier Province, and the rural areas of Sindh and Punjab of this province. What they said, okay, let's start this. Now how can we control this sort of populace? They said, let's start the system. We did not have, so this is a complete misnomer, we never had this Sardari system, an entrenched legal Sardari system. It was more like a sort of a village gathering, okay, he's elder, respected, okay, we'll give you an extra, you can have your say, you can advise us, you may guide us, but that was it. They had no power to determine anything. So the British, first of all, dismantled the pre-existing structure of adjudication. In Islam, the judiciary and the executive was always separate. The British brought them together at every level. They gave the Sardar the power to adjudicate matters. They gave the Sardar prestige. They raised his status up, gave him a few fancy titles, few gun salutes, a stipend. He became the revenue collector, pocketed some of the revenue, passed on the rest to the others. And he was the British agent in this area to administer, to police, and to ensure that the British interests were not in any manner undermined. Have we become independent after 75 years? Why did Pakistan come into being? Let me read the words of the founder, Muhammad Ali Jinnah. The criterion of a state of our own was means to an end, and not an end in itself. The idea was that we should have a state in which we could live and breathe as free men, and which could develop according to our own lights and culture, and where principles of Islamic social justice could find free play. And another quote of his, we should wholly and solely concentrate on the well-being of the people, and especially of the masses and the poor. Are we doing that? We've heard eloquent Mr. Salman Akram Raja and Ambardar, a doctor no less. She surpassed me. I'm not even a master yet. So good for you, Amber. We haven't really lost the elite capture, the predatory state that we were supposed to transform. There are many things left of that exploitative system yet, still. And I will, if I say these things, you may not believe it, so I'll actually quote text, because people think that the British rule was in some manner, what was happening here before was terrible. Till the British came, they gave women rights, they did this and that. It's absolutely untrue. They exploited this part of the world like they exploited your part of the world, Ireland. If I'm permitted to say that. We have another commonality I just discovered. We are both from the Middle Temple, but I'm sure I was there many years before you. I was called to the bar in 1982. So that makes 40 years of me being a barrister and almost 40 years of me being married to the lady in front. Yeah. So now I'll just read a few extracts. It's hard to swallow, but this is it. Now this is Lord Irwin addressing the Sardars at the Quetta Darbar on 21st of April 1927. The management of affairs and decisions of disputes are left so far as may be possible to the Sardars, tribal chiefs, and headmen. Okay, you will say yes, but the British were benign rulers. They surely appeals would be heard by them, and they would redress the wrongs that were committed by the Jirga. Incidentally, Jirga was 100% male. Another aspect of the Sardari system was absolute subjugation of women. Women's status was reduced to worse than that of chattel, and they were viewed, I mean, I don't know if I'll just give you, first let me read it. Now, this is a circular issued on the 3rd of September 1912. The agent to the Governor General and Chief Commissioner in Balochistan issued it. And he endorsed. We talk about Siyakari, Valvar, Vani. The British gave them legitimate legal cover, which they never had. And I quote, Siyakari, which literally means black deed or adultery, is by common consent a serious offense and one which in the present state of public opinion cannot be allowed to go unpunished. So then, and why, and another, why did they do this in this extreme form was because they thought that the Holy Quran, did not provide for an adequate punishment. And I'm here reading from Richard Burton's book published in 1851, Sin and the Races That Inhabit the Valley of the Indus. And I quote, "There are two causes in the province why the punishment for adultery was made so severe. In the first place, the inadequacy of the Quranic law, because it only prescribed a much lesser punishment of stripes. Secondly, the physical peculiarities of the people, as is often the case in warm and damp countries lying close to mountains. The amativeness of the female here appears to be stronger than that of the male." You would have thought I made it up, but actually it's a book written by an Englishman. So this was what had to be done. So please, we sometimes put on these rose-colored glasses and think that they were enlightened. They were not. They were the worst form of exploitative system. The status of women in Islam was reduced by the British, not enhanced. They were made like didn't matter. Going back to the, now giving you an precise case, and they introduced another concept, sharmana, that when adultery takes place, you can pay money to wash away the sharam or the shame. And who was the beneficiary in it? The husband's family and the British state. 2/3 went to the husband's family, 1/3 sharmana went to the state. You won't believe it, so let me read it. This is the case of Siyakara with a widow among the Mahmudani Sheikhan Khetarans. So the political agent to the Sibbi Shahi Jirga awarded rupees 300 then as sharmana, of which 200 was paid to the complainant and rupees 100 to the government. Is that the end of the matter? No. The disgraced widow was then, quote, handed back to the heirs of a husband who can give her for valvar to anyone they like. I mean, literally, they can sell her. The case was appealed, but by order dated 3rd July 1926, the Honorable Agent to the Governor General declined to interfere. This case appears at pages 119 to 121 of the Manual of Customary Law for Balochistan, not published post-Pakistan, but published in 1932, and under the instructions of the local administration, which was then British. So this, I wish more was researched on these aspects, that this structure was created. And there was another component to it, the introduction of the levy force. This was literally a private army. So there was, whether you call Sardar, Nawab, Malik, or whatever, everyone had the designations. They not only were revenue collecting agents, they were also empowered their people, their tribesmen, whatever, their supporters. The state would authorize them to induct levy personnel, like literally the police force of the area. So they would have financial power, they would have adjudicatory power, and they would have policing power. The British left, but how far are we still from what the founder dreamed Pakistan to be is a question which people more learned than me, particularly in this place of learning, will be able to answer. I just pose the question. So I'll just give you a few more examples. Now this, I mean, Lord Irwin's address to Quetta Darbar quote, just as your chiefs and sardars have great privileges, so they have great responsibilities. And it is only the whole-hearted and faithful discharge of those responsibilities that their privileges can be justified. The British went. Did they take the structure with them? Incidentally, this is the good aspect of British rule. They did not give themselves any land. Prior to the British coming here, land was generally owned by the king, but the people would have the right to use it, as Salman has very ably demonstrated, and they would not be displaced. So it would, the use of farak, they would be there endlessly, they maybe not be the owners of the land. But that ownership land suddenly became the state land. And then it was, this big chunk goes to you for your yeoman services to the British Empire, and it'll also give you a 21-gun or 10-gun salute or whatever, and this chunk goes to you, and this chunk goes to you. You take care of all the messy business of administering it, policing it, collecting revenue. Our interests are different. Those interests should be safeguarded. You handle things at the local level. This was British rule. They didn't fight major battles because they had a willing army of local supporters. I don't know, I mean, which major battle they came here and they vanquished the locals. I mean, leaving aside a few, like the 1857 War of Independence, but prior to that, prior to the British Empire coming here, it was the East India Company. So they just continued there, at least in Balochistan, no major battles were fought. And everybody wanted to, not everybody, whoever could, wanted to come on the right side of the British, become obedient, subservient, were given privilege. Their only one condition was you have to be totally 100% abject to British rule, and then you can crush those underfoot. That was all right. Do not look to us, do not demand anything more from us. So it was, I think, a brilliant system of governance by very few over a very large number of people. I don't know if there have been other duplication of this system elsewhere where this has happened. So now, I'll just cite from a book, how was it, I mean, am I saying it that prior to the British rule, the system here was much better? Let's see what the British themselves have to say. And this I'm quoting from the administration of justice in medieval India, and quote, according to MacDonald, the Muslims regarded the administration of justice as a duty, and with their armies everywhere went law and justice. Such as it was, jurists accompanied each army and were settled in the great camp cities which were built to hold the conquered land. And according to von Hammer, quote, the Islamite administration, even in its infancy, proclaimed in word and in deed the necessary separation between judicial and executive power. The British left the frontier crimes regulations. They used to constitute a jirga of heads of tribes or whatever we may want to call. They would submit a report to the deputy commissioner. And in a criminal case, they were civil and they were criminal. In a criminal case, he could uphold the conviction, he could set aside the conviction, he could increase the penalty, he could reduce the penalty, and he could remand the matter back. This came up before the court, and Justice Kayani, in a very sort of interesting sentence from the judgment, says, the law has been made a perfect ass, and the deputy commissioner can ride it to any one of 5 destinations. So that law went. Along comes Field Marshal General Ayub Khan. We supplanted a watered-down version of that called Ordinance 1 and Ordinance 2 of 1968. One dealt with criminal matters, one dealt with civil matters, sort of, okay, this has been struck down, so let's do some other hanky-panky and make it a watered-down version. Case of Begum Saida Isa, my mother, I was a counsel, we challenged it, and that law was also struck down in the Balochistan High Court. So we have to be continuously vigilant. Now, the only point which I would like to make about the Land Acquisition Act is, surprisingly, none of you have challenged, or even the gentleman here, the company aspect of that law. It does say "and company." Who's challenged it? Nobody. Not that I know of, because the Constitution of Pakistan does not use the word company. I'll just leave it there. Constitution of Pakistan says, yes, land acquisition, but public purpose only. Not, there's no word of company there. So that may, whether it is or it doesn't, or we'll have to find another chowkidar for Salman to to do a little more pro bono public work, or we'll have to get borrow Amber from, right. So we need to kind of change the way we think. I just need another little bit. The structure there prior to the British, you may not call it parliamentary democracy, you may not call it one man or one woman vote, but it was in some sense democratic, that you sort of participatory. I think probably the better word would be participatory. People were consulted, and this I read from another book. In every Pathan or Baloch tribe, there was democratic feeling. And this was done away, and I quote, "But the balance of power is to turn directly the headman by giving him the means to entertain armed servants of their own, and when supported by suitable allowances and the prestige of connection with our power, they both can and exert themselves successfully to keep the tribes in order." So this is T.H. Thornton from Colonel Sir Robert Sandeman, his life and work on our Indian frontier. So I'm quoting British sources, not biased, possibly prejudiced local sources. They defined what they wanted to do, what they had set out to do, and they did so very successfully. Land is, of course, is a major issue everywhere. Where does the wealth of a nation lie? Someone said about education, I think, yes, there's considerable wealth in education, but 2020 and 2021 figures, since we are at the Suleiman Dawood, what is it, center? It's an economic forum. So let me also impress you with some figures. What is Pakistan's budget? I mean, 2022 figures I'm mentioning. About 3 trillion rupees we spend just servicing debt, not repaying a single dollar or yen, pound, euro, or rupee, servicing debt. What are the next two biggest items? Next two biggest items are 470 billion on pensions. People like me, when I retire, will get a pension. You all will pay towards it. So 470 billion of your rupees is going towards that. What is the cost of total governance? 476 billion. Can you imagine? Now, I would imagine pension is kind of like a non-productive, sort of dead expense, and running the government is productive, useful expenditure. So government, you require 476 billion, pensions require that. And then comes, and I sadly say this, and it's been kind of alluded to as well, the politics of plots. I don't know if you're aware of the word pre-Bendelism. It's been described as the strong exploit and abuse the weak, tenacious and self-serving mechanism to retain power. So another word is elite capture, predatory state, in which divisions between private and public interest is totally dismantled. We have these beautiful societies. I drove through them, came here. Was there any one marla plot in it? I don't know. I mean, I don't think so. We won't, none of us will probably live in a one marla plot, but many, if they can find a one marla plot, they will consider them extremely lucky. So where is the right? Who speaks for their rights? The one marla plots, the half marla plot. One marla is 25 yards, I think, approximately. And cases have come to the Supreme Court of a land measurement which was less than a marla, sarsai. I didn't even know what that was. So I had to ask my colleague, how much is a sarsai? So he explained it to me. I said, you know, that piece of land has traveled all the way to the Supreme Court. Naturally, it means something to the person who has brought that matter to the court. I mean, we're talking about big housing schemes. By all means, are big housing schemes. If we are the richest country in the world, have them. But if we are not, if we have a begging bowl everywhere, then why don't we do this? Is keep whatever income taxpayers are like 5% of Pakistan, or 2%, I don't know the figure, but let's keep one marla plot. Let's start with that. I don't know, maybe you can go smaller than that, for the landless, for the impoverished. I mean, it reminds me of, I think I should just conclude on this, something from the Grapes of Wrath, John Steinbeck, who got the Nobel Prize for Literature, 1939. The book was 1939, I don't know when he got it, the prize for literature. The land fell into fewer hands, the number of dispossessed increased, and every effort of the great owners was directed at repression. So let us go back to where we started. The journey started prior to 1947. The journey started when the Qaid, the great leader, galvanized, brought together the All India Muslim League, who fought for the well-being of the people and especially of the masses and the poor. Let's give them a thought. Thank you very much.
Thank you very much, Justice Issa. This was a excellent contextualization of both law and history. And ladies and gentlemen, we have slightly a time issue, and for which I take responsibility, and there was a selfish reason for that. I don't think in so little a time was I or most of our audience were able to imbibe so much knowledge today during this discussion. So, if there's a time management issue, it's my selfish reason, and I'm sure you will agree with that as well. We were able to learn so much. So instead of fostering the discussion amongst the participants, we'd just like to slightly alter the proceedings, and we have about 10-15 minutes, and I would like to invite the audience today who have very kindly come to ask any questions from any of the participants. Ma'am.
I was working on the land acquisition laws for Pakistan also. It's basically in the entire region. Sri Lanka started working with the Asian Development Bank, who brought in the social impact because Asian Development Bank was funding projects in the region, and the developers were saying the development for whom, actually, because you're taking away from the poor, making roads for the rich, and it's not really helping the poor. So they came up with this 2007, Asian Development came up with the environment impact, the social impact, and providing the poor, the landless, and the non-title people a right in property and right into the investment, whichever investment is made. Sri Lanka got that law, India got that law, Bangladesh is at it. We started working on it in 2007, still not interested. RUDA, presently, you talked about defense, but RUDA is doing exactly the same, acquiring over 100,000 acres of farmland to build a city for the rich. So just a comment that it's still continuing in Pakistan in that way.
Oh, yes. Sorry, could you also state your name?
Saima Khwaja.
Saima Khwaja, okay, yes. Any further questions, ma'am? And could you also please state your name as well, introduce yourself, please? Thanks for that.
Hello, I am Dr. Nomana Amjad. I am a psychology professor. And we come head to head with law through our counseling cases mostly. I'm more of a rescue service and a referral service in terms of the counseling cases that come. And I have come across, for example, Pakistan Mental Health Act, which is still very, very undeveloped and unimplemented. But interestingly, when we come across right of divorce, and whether it was one divorce or two, so in that, my research took me to something which happened before Pakistan came into being, and that was that Allama Iqbal introduced the right of divorce for women in the Nikah-Nama. And obviously, there are three aspects. Either we don't know about it, or there is an ambiguity, and the third is that the implementation has not taken place. So that research kind of made me aware that in many of the counseling cases, if we made them aware that there is a chance for them to fight for the right of those who are termed as psychologically diseased, or those who run into life problems, and the law can help them. So any clarity about this right of divorce for women? What should I tell my counseling cases? And the one divorce or two divorce or three, fiqh's divide. So fiqh is very much a men's club. So that's where I had to do a lot of research. Also, Shariat mein divorce ho gayi hai, but legally you are not divorced. So the law of succession still applies to that women. So where should I refer them, and how can I help such people?
Just very quickly, and then we can talk more about this later as well to save time. So post the reforms that I discussed, women do have a right to divorce as long as it is delegated to them by their husbands in the Nikah-Nama. So A, it has to be delegated, and B, it's only in that case is it a unilateral right. In case that is not there, they can still dissolve their marriage through khula proceedings, which are also not lengthy and cumbersome now. However, in case they do that, they lose their right to, they lose their financial right to the haq meher amount. So very quickly, that's an answer to that question. And again, to your question of the teen talaq, ek talaq, do. Now, one of the purposes of the 1961 ordinance, one of the impetuses behind it was to resolve that ambiguity, and therefore a provision was introduced which said that upon the pronouncement of divorce, at least a 90-day period has to elapse before it is finalized by the relevant authority. However, subsequent to that, ambiguity has been created by how courts have interpreted that provision, because what they have effectively interpreted it is to mean that even in the absence of the registration after the 90-day period, a divorce can nonetheless be valid. And there were a number of social reasons why I think that had to be done, because practically speaking, many people don't even register their marriages, let alone register their divorces. But what that meant was that the effectiveness of that provision, which was to give some stability to women, and so that the act of divorce can actually be recorded rather than just based on the word of the man, the effectiveness of that has been seriously diluted.
I'm Ashraf Chaudhary, here, sir, this side. My question is general in nature. It's not particular to any panelist. Keeping in view the situation which has evolved over the 75 years, because we are talking about 75 years, we have seen different like legal system, in the economic system, in the I should say the military system, what we have. Do we see any hope at, I'm 50-year-old and may I have next 10 year, 20 year, 30 year of my age. Can I expect to see any good thing coming up in next 10, 20 years for Pakistan?
Sir, please, sir.
Sir.
20, 30 years. Can you hear me or do I need the mic?
No, it's fine, sir.
Okay. You know, I'll just say it in Urdu. صحابی کرام نے پوچھا رسول اللہ صلی اللہ علیہ وسلم سے اگر میرے ہاتھ میں 2 بیج ہوں یا پودا ہو میں کیا اور قیامت آ جائے میں کیا کروں؟ جواب کیا ملا؟ بو دو. پہلی بات. دوسری بات اگر آپ if you have for the benefit of Justice Maura McGowan, I hope I've pronounced it correctly, that the Prophet was asked by his companion that if I have a seedling or a plant in my hand and doomsday comes, what should I do? His answer was to plant it. So yes, that you have to do. My question to you would be, what have you done about it?
Sir,
we must all strive.
Sir, we must all strive, but the issue is the people who matter, the people who have power or authority to do, like our parliamentary system, our governance system, because our governance is, I think, the poorest.
Mr. Salman Akram Raja gave you an example of a one frail woman writer, what she did. She was not in parliament, she was not in power, she was nobody. And she brought about a sea change. So never underestimate the power of the individual.
Thank you, sir.
Next, we just have time for 2-3 more questions. You'll come. Gentleman over here, in the second row.
Assalamu alaikum, Naveed Arshad. I'm a citizen of Pakistan, also happen to be faculty at LUMS. تو میرا سوال اردو میں ہوگا. یہ ہوگا کہ ہمارا جو آئین ہے اس کی جو پہلی 3 لائنیں ہیں اس میں ہم کہتے ہیں جی کہ اللہ آلمائٹی از رننگ دی یونیورس اور ہم نے سر اس کو فالو کرنا ہے. ایز اے سٹیزن آف پاکستان یا پاکستان کے ایک شہری کی حیثیت سے مجھے لگتا ہے کہ ہم نے اپنے لاء کے اندر اسلامک ٹچ لاتے نا اس کو زیادہ خراب کر دیا. نہ ہمارا لاء ٹوٹلی اسلامک ہے اور نہ ٹوٹلی سیکولر ہے. اور اس کی 2 ایگزامپل میں آپ کو دوں گا. جس طرح کہ اب یہ 1961 کا وومن جو مسلم فیملی لاء تھا کہ اس میں آپ نے کہا کہ جی ایک تب تک آپ دوسری شادی نہیں کر سکتے جب تک آپ پہلی وائف سے اجازت نہ لیں. اب بیسیکلی آئی ڈونٹ نو کہ دنیا میں کون سی خاتون ہوگی جو کہ اجازت دے گی دوسری شادی کی. تو اسینشلی آپ نے اس کو منع کر دیا, آپ نے کہا نہیں کرنا, لیکن کیونکہ ہے ہاں ہم نے الاؤ کیا ہوا ہے. دوسرا اسلامک بینکنگ, ہم نے کہا جی اسلامک بینکنگ لے آئیں, لیکن اگر آپ کبھی ان کا کانٹریکٹ دیکھیں جو اسلامک بینکنگ کے, فار ایگزامپل میں نے گاڑی لون لینی ہے یا اسلامک بینک سے دوسرے بینک سے, کلازز تقریباً ساری سیم ہیں, صرف ناموں کا فرق رہ جاتا ہے. تو یہ جو ڈسیپشن, یہ دھوکہ بازی کیوں ہے ہمارے لاء میں؟ یہ یا تو کہہ دیں جی کہ سیکولر ہے تو سیکولر رکھیں, اسلامک ہے تو پھر اسلامک رکھیں. تو
بینکنگ ٹرانزیکشن سے بڑا اٹس ویری ریلیونٹ ان دیٹ. کین آئی آسک سلمان صاحب ٹو ریسپونڈ ٹو دیٹ؟
Okay.
He's got a view on this, and I know that.
No, Dekhiye, I must say I am acting for the State Bank of Pakistan. I acted before the Shariat Court for the State Bank, and I am now before the Supreme Court on behalf of the State Bank of Pakistan. اس لیے میں بہت بات نہیں کرنا چاہتا اس پہ. لیکن یہ جو ربا کا معاملہ ہے یہ بہت پیچیدہ معاملہ ہے, اور جو بحث ہم نے اسٹیٹ بینک کی طرف سے شریعت کورٹ کے سامنے کی, اور اب سپریم کورٹ میں بھی وہ ہوگی, اس حوالے سے وہ یوں ہے کہ دیکھیں, یہ کہہ دینا کہ آپ ہر چیز جو ہے, ہر جو آپ کا معاہدہ ہوگا وہ شراکت پر ہوگا اور اس میں آپ جو ہے نفع نقصان دونوں کے جو ہے سزاوار ہو سکتے ہیں, یہ بات ٹھیک ہے. لیکن بہت سے معاہدے اور بہت سی ضروریات ہماری معاشی اس نوعیت کی ہیں کہ ابھی تک کسی کو سمجھ نہیں آیا کہ اس کو ہم کیسے اس سانچے میں ڈھالیں. میں 2 مثالیں صرف آپ کو دیتا ہوں جو عدالت کے سامنے بھی ہم نے رکھی, اور ابھی میری کچھ عرصہ پہلے مفتی تقی عثمانی سے اس پہ ایک سٹنگ ہوئی خاصی لمبی. انہوں نے وہ تقاضا کر رہے تھے کہ اسٹیٹ بینک جو ہے اپیل واپس لے لے سپریم کورٹ سے. تو ان سے 2 سوال میں نے کیے کہ آپ ان کا جواب دے دیں تو ہم واپس لے لیتے ہیں. ایک ان سے گزارش یہ کی میں نے کہ دیکھیں جو حکومت ہے، حکومت ایک بجٹ ڈیفیسٹ رن کرتی ہے. یہ ہماری اب ضرورت ہے. ٹیکس اتنا نہیں ہو سکتا کہ آپ جو آپ نے تنخواہیں دینی ہیں، پینشنز دینی ہیں، گولہ بارود خریدنا ہے، وہ آپ نے بہرحال خریدنا ہے، آپ نے ریاست کو چلانا ہے. تو ان چیزوں میں تو کوئی شراکت داری نہیں ہے، کوئی نفع نقصان نہیں ہے. تو اس کے لیے ہم کیا کریں؟ تو جواب یہ ملتا ہے کہ آپ اسلامی طریقہ اپنائیں، سکوک جاری کریں. اچھا، سکوک جو ہیں، پاکستان کی ریاست 2002 سے آج تک 44 سکوکس جاری کر چکی ہے، جن کی ٹوٹل ویلیو جو ہے سب ملا کر وہ غالباً کوئی 60-62 بلین بنتی ہے. جبکہ ہمارا جو اینول بجٹ ڈیفیسٹ ہے، وہ نمبرز کچھ آپ کو بتا رہے تھے، وہ ہنڈریڈز آف بلینز میں جاتے ہیں. ٹھیک ہے نا. اب سکوک میں آپ کرتے کیا ہیں؟ آپ کہتے ہیں ہم نے علامہ اقبال انٹرنیشنل ایئرپورٹ بیچ دیا اور واپس خرید لیا، ہم نے کراچی کا ایئرپورٹ، جناح ایئرپورٹ بیچ دیا، خرید دیا، ہم نے پورٹ بن قاسم بیچ دیا، پھر واپس. ایک سیل بائی بیک ہی ہے نا وہ. تو جو ہیلا جس کی آپ بات کر رہے ہیں، تو وہ ہیلے سے زیادہ کچھ نہیں ہے. اور کون سے وہ اثاثے ہیں کہ آپ موٹر وے بیچ دیں گے اور کہیں گے اب ہم نے واپس خرید لی ہے اور اس کی ادائیگی ہم نے اتنے سالوں میں کرنی ہے اور وہ ایک نفع کے ساتھ ہم کریں گے. تو یہ ریاست کے لیے ایک بہت بڑا معاملہ ہے اور اس کا کوئی جواب مجھے ابھی تک کسی سے تسلی بخش نہیں ملا. یہ سلمان داؤد اسکول آف بزنس میں بیٹھے ہیں، شاید کوئی بتائے کہ ریاست کیسے چل سکتی ہے، جو اس کا بجٹ ڈیفیسٹ ہے اس کو کیسے پورا کیا جائے. جب وہ پورا نہیں ہوتا تو اس کے لیے آپ کو بہت سی انسٹرومنٹس کا استعمال کرنا پڑتا ہے. ٹریجری بلز ہیں، PIB بانڈز ہیں، ان کے اوپر آپ کو ایک ریٹرن دینی پڑتی ہے. وہ کوپن بیسڈ ریٹرن ہوتی ہے، وہ مارکیٹ میں ٹریڈ بھی ہوتی ہیں، اس سے ایک ییلڈ کا تعین بھی ہو جاتا ہے. تو ایک تو یہ اسپیکٹ ہے. دوسری ایک اور مثال میں آپ کو دیتا ہوں. ہمارا سول پروسیجر کوڈ ہے، اس میں ایک سیکشن ہے، سیکشن 34، جو یہ کہتا ہے کہ جب کوئی عدالت کوئی ڈکری جاری کرتی ہے تو عدالت کو اختیار حاصل ہے کہ اس ڈکری کے اوپر ایک رقم جو ہے تعین کر دے کہ جتنا عرصہ یہ رقم حاصل نہیں ہوگی ڈکری دار کو، تو وہ رقم اس پہ ایڈ ہوتی رہے گی، اس کا اضافہ ہوتا رہے گا. اب مثال کے طور پہ آپ نے کسی کو اپنا مکان کرائے پہ دیا اور وہ کرایہ دار اس پہ بیٹھا رہا، کئی سال بیٹھا رہا، اس نے کرایہ بھی نہیں دیا، وہ قابض ہو گیا، آپ نے عدالت سے رجوع کیا، آپ کو مل گیا ایجیکٹمنٹ کی، آپ کو مل گئی ڈکری، آپ نے اس کو فارغ بھی فرض کریں کر لیا 1990 میں. لیکن آپ کا اس وقت ایک جو ان پیڈ رینٹ تھا، کرایہ تھا، وہ تصور کر لیں کہ 1000 روپے تھا. اب ہمارے ملک میں ایگزیکیوشن جو ہے وہ عام معاملات میں بھی 10-15 سال لیتی ہے. وہ 1000 روپیہ حاصل کرنے میں شاید آپ کو 15-20 سال لگ جائیں گے. اب 20 سال کے بعد اگر آپ کو وہی 1990 والا 1000 روپیہ ملتا ہے تو آپ کو کچھ بھی نہیں ملا. تو سیکشن 34 آپ کو ایک طرح سے یہ تحفظ دیتا ہے کہ جو آپ کی ڈکری کی رقم ہے وہ قائم رہے گی، اس پہ 6%, 8% سالانہ اضافہ ہوتا رہے گا. لہٰذا 20 سال بعد بھی اگر آپ کو ڈکری کی رقم ملتی ہے تھرو ایگزیکیوشن اجرا جسے ہم کہتے ہیں، تو آپ کو کچھ نہ کچھ مل جائے گا. اب شریعت کورٹ نے اس کو بھی کالعدم قرار دے دیا. انہوں نے کہا یہ بھی ربا کی ایک شکل ہے سیکشن 34. تو میں نے گزارش یہ کی، صرف ایک مولانا سے نہیں، بہت سے حضرات سے ملاقات ہوئی ہے، علماء سے، کہ ہمارا پورا، میں آپ سے گزارش کرتا ہوں، جو عدالتی نظام ہے وہ سیکشن 34 پہ کھڑا ہے. اگر کل آپ کو اور مجھے پتا ہو کہ جو ہمیں ڈکریاں ملتی ہیں ان کی رقم تو جامد ہو جائے گی اور 20 سال بعد جب میں اس کو ایگزیکیوٹ کروں گا تو مجھے وہی 1990 والے 1000 روپے ہی ملیں گے، تو آپ اور میں عدالتوں میں جانا چھوڑ دیں گے. ہم پھر قبضہ گروپ سے کوئی رابطہ کریں گے، ہم کوئی کنٹروٹے ڈھونڈیں گے، ہم پورا آپ کا عدالتی نظام بکھر جائے گا، کیونکہ ہم پھر ڈکریاں لینے میں کوئی ہمیں دلچسپی نہیں رہے گی. تو یہ 2-3 بڑے بنیادی نوعیت کے سوالات ہیں جن پہ آپ کی جو معاشی بھی اور عدالتی قانونی جو عمارت ہے وہ کھڑی ہوئی ہے. تو ان کو بہت غور سے سوچنا پڑے گا ہمیں. ابھی یہ میں نہیں سمجھتا کہ ہم وہاں پہنچے. ایک آرگینک گروتھ ہو رہی ہے، اسلامک بینکنگ ہر سال 10-20-30% بڑھتی ہے. جو یہ 7 بینک ہیں اب جن کو خصوصی طور پہ اسلامک بینکنگ لائسنس دیا گیا ہے، دے آر دا فاسٹسٹ گروئنگ بینکس ان دا کنٹری. تو وہ ایک آرگینک گروتھ ہو رہی ہے، اس کو ہماری گزارش یہی ہے کہ ہونے دیں. یہ معاملات اپنی جگہ ہیں، ان کا جب حل ملے گا تو پھر اس حل پہ عمل کیا جائے گا.
I'm really sorry. We are well over time and I'm afraid we cannot take any more questions. Thank you for your patience and for your forbearance. Once again, I would like to thank all our speakers today. It was a wonderful, very engaging discussion. I think I say for myself and I say for everyone else in this audience that we have learned a lot at the end of it. So, ladies and gentlemen, please, a round of applause for all the speakers. And I'm also told that lunch is being served. So, they say a hungry man is an angry man. So I think we should all disperse for lunch. The next session is starts at 2:30. So I would request all of you to be back here by 2:20 before that. Thank you once again, everyone.